Good afternoon. I'm Chilton Varner, the president of the Supreme Court Historical Society. It's my honor to welcome you to this virtual lecture this afternoon to be delivered by Professor Sam Erman of the University of Southern California's Gould Law School. Happily, today is Constitution Day, the day when the delegates to the Constitutional Convention of 1787 signed the newly created Constitution. That day, now 234 years ago, is commemorated annually with events around the country, focusing on the importance of the Constitution in our world and our lives. It's especially fitting that the Supreme Court Historical Society should take part in this annual commemoration. September 17, today, happens to be also the birthday of the Society's founder and first honorary chair, Chief Justice Warren E. Burger. The Society continues to pivot and adjust as the pandemic proves its stubbornness. We recognize the value of having these virtual events that are readily accessible to our members all around the country. After that, these programs can be archived permanently on the Society's website. So even once that we can resume our in-person events, we will share those events with virtual programs, even when the Supreme Court building reopens to the public. As I mentioned, today's program features a lecture from Sam Erman that is based on his 2018 book entitled Almost Citizens: Puerto Rico, the U.S. Constitution, and Empire. Professor Erman is going to talk for about 30 minutes and then he'll take questions. Please submit any questions or comments that you may have to the Society via the Q&A feature of your Zoom connection. Our Executive Director, Jim Duff, will be reviewing your comments and questions, and he will present as many as is reasonably possible to Professor Erman for his commentary. Sam Erman is a scholar of law and history. His research and teaching focuses on citizenship, the Constitution, empire, race, and legal change. He is currently co-authoring a project concerning the history of birthright nationality in England, France, and the United States. Now, the book that is the inspiration for today's talk, the one entitled Almost Citizens, was published by Cambridge University Press in 2018. You may obtain a signed copy of that book if you visit the website of the Historical Society gift shop. Professor Erman has been good enough to provide signed copies for your purchase, and so we encourage you to visit that website. In addition to the book, Professor Erman's prize-winning work appears in leading legal and peer-reviewed journals, including Michigan Law Review, California Law Review, and the Journal of American Ethnic History. Prior to joining the USC School of Law faculty, Professor Erman served as a clerk to Supreme Court Justices John Paul Stevens and Anthony Kennedy. He also clerked for U.S. Court of Appeals Judge Merrick Garland, who is, of course, now the Attorney General of the United States. One more factoid about Professor Erman. He received both his JD and his PhD in American culture from the University of Michigan. I'm delighted to welcome Professor Erman to the Society's virtual platform. He is going to entertain and inform us on a very interesting topic. Professor Erman, the podium is now yours.
It is such a pleasure to be here. Thank you for that lovely introduction. Thank you to the Society for hosting me today. The Society is a wonderful institution, and I couldn't be prouder to get to participate. And given this event, I should also say a special thank you to the Supreme Court in general, and especially to the Supreme Court Library. During my year having the privilege, the clerk at the court, the folks at the library were just astounding interlocutors, helping me identify sources that might be helpful for this project, helping me figure out how to get my hands on them. The Supreme Court Library really is a treasure, and I was just so lucky to have the chance to interact with everybody there. So I used to have to remind audiences when I would talk about my project that Puerto Rico was part of the United States. Now, of course, its plight makes headlines. As you know, Puerto Ricans have no vote for Congress or president or on constitutional amendments. They are at the mercy of US grace, and that has sometimes been in quite short supply. This has been particularly evidenced with recent crises. So there was, to start, an enormous debt crisis, $100 billion. That worked out to about $100,000 per household on the island, which is about 5 years of household earning. If Puerto Rico had been a state, there would have been a forceful federal response long ago. As it stands, Puerto Rico is confronting a generation of lost economic growth. Then, of course, there's Hurricane Maria. It devastated the island's already fragile infrastructure, and the federal response was a shadow of what it was in states. There was loss of life, a long, incomplete recovery. And my book and this talk seek to address, how did this all happen? How did the United States, the world's longest running experiment in democracy, come to be home to Puerto Rico, the oldest colony on Earth? Specifically, how does the type of colonialism practiced in Puerto Rico end up being constitutional? So it begins with war. The United States invaded Puerto Rico in 1898 and annexed it in 99. And I'm going to make 3 arguments about what followed. The first is a what. A big change happened between 1898 and 1925. Prior to 1898, it was conventional legal wisdom that all Americans other than Indians were US citizens, that all American lands other than DC were current or future states, and that full constitutional rights extended wherever US sovereignty did. These principles arose from what I term the Reconstruction Constitution, the constitutional settlement that emerged out of the Civil War. And by 1925, all 3 of these had reversed. So you might ask, who made these changes? The answer is it was actors from across and beyond the federal government. The changes took place outside of courts as often as within. They involved lawyers, bureaucrats, judges, of course, more modestly situated individuals, lawmakers, often working together. And finally, we might ask, how did it happen? The answer is through creative ambiguity, evasion, and incrementalism. Its pathways were dicta and minority opinions, narrow holdings, ambiguous reasoning, underdefined terms, bracketing of questions, strategic concessions, proposals by potentially non-final decision makers, and maybe most importantly, cross-branch signals of openness to novel approaches. The Dune Doctrine itself, as you can see, had unwieldy terms. Its uncertain effects also exemplified the method. A powerful undertow of racism shaped and animated the legal arguments. These arguments were often cast and contested with domestic imagery of husbands and wives and lovers, or parents and children. A key context for all of this was the ongoing US struggle with the legacy of the Civil War. Well into the 20th century, fights over the past of Reconstruction and the future of empire were inextricably intertwined. The aftermath of the Civil War did provide Republicans and Democrats reasons to oppose the imperial turn. Republicans were the party of emancipation. They gave meaning to freedom by sanctifying the Reconstruction Constitution. Although National Republicans had largely ceased fighting for Black voting rights by 1898, they remained formally committed to them, a position that was at odds with colonial rule. Democrats denounced Reconstruction as federal tyranny and Black misrule. They celebrated its overthrow, which brought them to power throughout the former Confederacy. As members of the party of white supremacy, they abhorred the prospect of statehood, citizenship, and rights for non-white residents of the Philippine Islands. And because Democratic dominance in the South remained tenuous, the prospect of national Republicans wielding federal power was also, to them, an outrage. At the same time, both Republicans and Democrats had reasons to reconcile Reconstruction with empire. Those reasons were rooted in a racism so ingrained among US officials that they could not imagine a world structured otherwise. Many Republican leaders drew from the failure of Reconstruction the lesson that racially inferior people could not be entrusted with self-government. Those Republicans favored imperial governance outside the strictures of the Constitution. As Democrats' stranglehold on on Southern politics grew ever tighter, they increasingly saw empire less as a threat to white supremacist policies and more as a new field for their implementation. Citizenship will provide us a helpful lens as we proceed through this material. It was and is a powerful middle ground between officialdom and the populace. It's a language that spanned and spans both domains. Focusing on it is a way to eliminate how officials and private actors at a variety of levels together drove historical change. As you've heard, the talk is drawn from my book, which takes a narrative approach to events. Its guides are four remarkable Puerto Ricans who sought US citizenship and their federal interlocutors. What emerges is a story of almost citizens, the people of Puerto Rico who were deemed neither citizens nor aliens and who lived in a land deemed neither foreign nor domestic. The story begins at the end of the 19th century with the annexations of Puerto Rico, Hawaii, Guam, American Samoa, and the Philippines. These brought millions of people of African, Asian, and indigenous Pacific Island descent into the United States. Would they be citizens? If so, what would it mean? Citizenship would not necessarily bring full rights to participate in public life. Women, African American, Mexican American, and Chinese American citizens well knew that. Here, as we think forward, it will be useful to peer back to 1865 for a moment. This is the end of the Civil War. The Union was saved, slavery effectively ended, the South in ruins. The North and Republicans were ascendant. The end of slavery was a revolution, but how far it would go was unclear. To make it far-reaching, Republicans won ratification of 3 constitutional amendments. The 13th ended slavery, The 14th determined who were citizens and guaranteed them privileges and immunities the antebellum case law suggested were far-reaching. The 15th reinforced that notion by protecting voting. Dred Scott's infamous holding that free African Americans were not US citizens or citizens of states was reversed, yet the case continued to stand against perpetual US colonies. The result was that rights-rich citizenship and eventual statehood became inevitable consequences of annexation. So for 3 decades, the United States kept stopping short of annexing new lands. Where US borders already extended, the United States consolidated control. Subordination of American Indians is the key example. Abroad, the United States exercised power without annexing. They imposed US laws on disputes involving Americans in parts of East Asia. They won favorable treaties with Hawaii and the Dominican Republic. In Samoa, they opted for an unwieldy co-governance agreement with Great Britain and Germany rather than annex. And in Venezuela, they asserted the right to prevent British action even as they disclaimed all sovereignty. As one prominent proponent of US expansion declared, the Reconstruction Constitution was a lion barring the path of expansion. So when US military commanders reached Puerto Rico, they articulated a future for it under the Reconstruction Constitution. Citizenship, rights, and statehood would follow annexation, they declared. But then, Republican President William McKinley decided to annex the Philippines. Federal officials willing to bring small islands with small populations into the United States now balked at integrating the much larger, much more populous Philippine Islands. In officials' words, it was home to uniquely large, ill-led, quote, utterly alien, and racially inferior population of, quote, Malays, Tagals, Filipinos, Chinese, Japanese, Negritos, and various more or less barbarous tribes. When it came time for the Senate to ratify the treaty, white supremacy dominated the debate. Neither side had any intention of giving Filipinos citizenship, full rights, or statehood. Debate centered on whether the United States would dominate Filipinos or be ruined by them. McKinley's Republican allies argued that the Constitution permitted imperial governance in general and the withholding of citizenship, rights, and statehood specifically. Democrats, fearful of federal overreach, disagreed. They viewed the Constitution as a bulwark against federal power. But they were quick to crow that Republicans who had supported Reconstruction now enthusiastically backed an openly racist imperialism. In early 1899, a compromise was struck. Ratify the treaty, but disclaim the consequences. So the Senate declared that ratification was, quote, not intended to incorporate the inhabitants of the Philippine Islands into citizenship of the United States, nor to permanently annex said islands as an integral part of the territory of the United States. The idea here was that only subsequent litigation would culminate the taking in of each place ceded by Spain. McKinley then hired this guy, Elihu Root, to be Secretary of War. Root had zero military experience, but he was among the most highly respected lawyers in the nation. Because the War Department governed post-war Puerto Rico, the Secretary was uniquely positioned to lay out a constitutional theory of empire and present it to Congress and to the courts. And Root had a simple view: anything goes. Citing cases involving African Americans, Mormons, Chinese, Americans overseas, aliens, and other disfavored groups and places, Root argued that the Constitution, self-government, citizenship, and statehood could all be withheld from the new acquisitions and their people. Republicans now lit on the idea of legislating for Puerto Rico, seeing what the Supreme Court did, and then, only then, deciding what to do with the Philippines. So they treated Puerto Rico, as Root had suggested, stingily. No citizenship, no statehood promise, no full constitutional rights or meaningful self-government. Instead, they put a modest tariff on mainland island trade, setting up a test case on whether Puerto Rico was part of the United States. Still fearful of federal power, Democrats complained that, quote, no such dangerous and absolute power was ever before lodged in an irresponsible carpetbag government. The Supreme Court test case that Congress had envisioned came among the series of disputes concerning the constitutionality of empire known as the insular cases. In the 1901 Downs versus Bidwell decision, the court held that the tariff that had been imposed on trade was constitutional, but no decision garnered 5 votes. The most notable opinion was Justice Edward Douglas White's concurrence, which proposed the novel and ambiguous category of unincorporated US territory. This was a place that was neither foreign nor domestic. What rights would extend there and whether citizenship would extend there were both left unclear. And no majority was ready to elevate this ambiguous innovation into binding doctrine. So now all the federal branches had spoken, and the status of Puerto Rico and of Puerto Ricans remained unclear. And this created space for the Puerto Rican protagonists of my book and this talk to step to center stage. The first is Federico De Gateau. He was a lawyer, a legislator, a politico and a poet, a novelist and a gentleman, an all-around liberal reformer intellectual, and if news reports were to be believed, something of a romantic heartthrob. He had sought rights, citizenship, and self-government during Spanish rule of Puerto Rico, and now in 1900, he was Puerto Rico's first elected representative to Washington. There, he launched an armada's worth of claims to citizenship, which he hoped would eventually also bring rights and statehood. He sought entry to the Supreme Court bar and a US passport, both of which ostensibly required citizenship. He imported a Puerto Rican artist's painting and then claimed a tariff exemption for works by American artists. He demanded that Puerto Rico receive the same quota of civil service jobs as other territories and that Puerto Ricans be permitted to vote. He supported his claims with arguments calculated to correct white mainlanders' quote, mistaken impression that Puerto Ricans were not their racial equals. Editorial cartoonists of the day caricatured his people as akin to African and American Indian, quote, savages, recent immigrants from Europe, children, and women. So De Gateau nearly daily presented himself as an exemplar to legislative, judicial, and executive officials, the media, and academics. Drawing on a stylized history of Spanish-era battles, he extolled Puerto Ricans' virtuous, viral, historical pursuit of liberty. In response, officials typically bent without breaking. They thus permitted Puerto Ricans to have passports, but only after eliminating the citizens-only rule. De Gateau's break finally came from an unexpected source, Isabel Gonzalez. Not yet 21 in 1902 and facing financial hardship, she migrated from San Juan to New York. There, she met her uncle Domingo Collazo, who had long experience in such journeys. Collazo left Puerto Rico in the 1880s. He joined the revolutionary movement against Spanish rule in Cuba and Puerto Rico. and he founded this racially egalitarian revolutionary newspaper. Eventually, an insurrection broke out in Cuba, but not Puerto Rico. Collazo sought U.S. intervention in his homeland, so joined its U.S. invasion. But U.S. rule did not bring Puerto Rico self-government, citizenship, or full rights. So Collazo returned to New York. And that meant that he was available to come to Ellis Island to promise to provide for Gonzalez and to take her to the city. Unfortunately, immigration inspectors were dubious of the unmarried mother who was also 8 months pregnant. So the next day, Gonzalez's brother, Luis, came with a different story. He cast Gonzalez as the victim of rapto, a Spanish offense akin to breach of marriage promise or seduction. Under Spanish law, a man found to have had sex with a virgin after a false promise of marriage would be forced to marry the woman or face criminal sanction. Luis now declared his family ready to force the matter. Isabel had a lover who had declined to marry her, but, quote, as soon as I have my sister with me, we are going to have them married. I have also gone to the authorities and told them. My aunt has made arrangements and is sure of making a reconciliation and will have them married. Inspectors were incredulous. Judging Gonzalez to be an undesirable alien, they denied her entry. So now Collazo swung into action. He brought a habeas action for Gonzalez that the Supreme Court took up on appeal. He convinced leading constitutional law expert to argue it, and the two of them drew De Gateau into the case as a friend of the court. The question presented was, were Puerto Ricans aliens subject to immigration laws, citizens free to enter the mainland, or something in between? Two precedents existed for in-betweenness. The first was the infamous antebellum Dred Scott v. Sanford decision that free African Americans were not citizens. As Gonzalez's lawyer told the court, such, quote, views have been repudiated by the American people in the Civil War, by 3 amendments to the Constitution of the United States, by this court, and by 40 years of advancing civilization. The second precedent was the 1884 Elk versus Wilkins decision that American Indians born into tribal relations that they later severed did not thereby become U.S. citizens. That precedent was a poor fit for Puerto Ricans because Puerto Ricans were born owing primary allegiance to the United States and not to a separate tribe. Predictably, the lawyers in the case disagreed. The government demanded that Puerto Ricans be declared aliens to inoculate the mainland against objectionable foreign bodies. Gonzalez's lawyer demanded citizenship, then cited the degraded legal position of African Americans to reassure that it would bring its bearers no more rights than other empires offered their colonial subjects. De Gateau claimed for Puerto Ricans such as himself a robust citizenship associated with white men, civilization, and legal, economic, political, and military domains. In early 1904, the Supreme Court unanimously held that Puerto Ricans were not aliens and so could travel stateside. It did not reach the citizenship question. That silence was understood to signal an openness to non-citizen nationals. Here, once again, vagueness was valuable to the court as it adjusted constitutional democracy to empire. The decision spelled De Gateau's political ruin. The United States had consolidated his colonial regime on his watch. He lost re-election and withdrew from public life. Nonetheless, his claims had won islanders concrete gains: non-alien status, passports, access to the mainland, federal jobs. Gonzalez now joined with Collazo to seize a public voice by publishing letters in leading New York newspapers. Drawing on popular analogies between annexation and elopement, she expressed outrage that Puerto Rico had been a victim of a political rapto. US officials had promised her people liberation for their allegiance, but then provided no citizenship, self-government, or rights. But those officials were not subject to criminal culpability for the betrayal. No, Gonzalez was the one subject to, quote, detention at Ellis Island for the crime of being an alien. I love that paragraph. In the case record, Gonzalez is a poor mother of multiple out-of-wedlock children whose relatives go in for alternative facts. Her sophisticated cross-cultural, political, legal analysis was a find that floored me. It also got me digging. In De Gateau's personal papers, I found this letter by her, demonstrating she was among the few Puerto Ricans who could write fluently. While reading microfilms of 20 years of island newspapers, I found a letter by Collazo describing how he joined with Gonzalez to write the letters that newspapers published. Text searches in newspaper databases revealed letters in Gonzalez's name issuing for over 2 decades. Directories, municipal records, census sheets, and newspaper coverage showed that she married during her appeal. And that was grounds to stay in the country, but she hid that marriage so that she could continue her test case. Then came my break, Belinda Torres Mary, one of Gonzalez's great-granddaughters. She contacted me, and it turns out she's a crack genealogist, so we started collaborating. According to family lore, Gonzalez had married a gentleman as a teenager. And I should say, of this I was dubious, for whose family tree doesn't include a mythical duke or a wonderful aristocrat that can't quite be named? But Belinda suggested that maybe gentleman was a name. So I went into the church records looking for the Spanish translation, and indeed Gonzalez had married Señor Caballero, Mr. Gentleman. Municipal death records showed that he had died young from tuberculosis and left his pregnant, now widow, with their baby daughter. Put it all together, and you have a woman who carefully hewed to the norms of family respectability, publicly portrayed herself otherwise to pursue her legal political goals, and then called out the United States for its actual immorality along similar lines. Okay, so back to our main narrative. Collazo now used his involvement in the case to comment in print on it in Puerto Rican newspapers. Soon, he completed his transformation from printer to journalist and was writing this regular column for Puerto Rico's leading newspaper. Here, he promoted a political deal between the leading political party on the island and the mainland Democratic Party. The choice of Democrats, it should be noted, was born of a desperate process of elimination. He had tried Republicans first, but now cast them as, quote, bloodhounds of imperialism. Remember, Republican lawmakers had not naturalized Puerto Ricans. Republican lawyers had opposed his niece's suit for citizenship, and Republican Supreme Court appointees had declined to recognize Puerto Ricans as citizens. What Collazo did not emphasize were Democrats' shortcomings as allies. Democrats had won few national elections since the Civil War, and every passing year lessened their fear of Reconstruction, which was the reason that they opposed empire. Still, Democrats' hazy promises of self-government just over the horizon enticed the otherwise disillusioned Collazo. Presuming that Democrats would elevate anti-imperialism above anti-Puerto Rican racism, he declared that the redemption of Puerto Rico was imminent. Now we turn to the book's final protagonist, Santiago Iglesias, who shared Collazo's optimism for the redemptive power of federal governance. Iglesias was in his mid-30s, a seasoned labor leader who was now at the head of Puerto Rico's labor movement. His prominence owed much to his warm working relationship with Sam Gompers, the president of the largest and most powerful U.S. labor organization, the American Federation of Labor, or AFL. The men in their organizations were odd couples. The AFL was a trade union. It discriminated against people of color, it feared labor migration, and it stood against empire. Iglesias's constituents were racially mixed population, often agricultural workers, residents of a colony who were permitted to travel at will to the mainland. The AFL, nonetheless, was long one of Iglesias's staunchest allies and often his only one. Island politics, after all, were dominated by elites. They had little sympathy for muscular self-assertion by workers. Increasingly, the largest employers on the island sprang from mainland corporate investment. These distant sources of capital took a similarly dim view of labor organizing. That really left only federal officials as potential allies, so Iglesias courted them. He declared workers to be American patriots, drawing a contrast to ostensibly anti-American island politicians. He eschewed industrial strife to promote a dependent citizenship, asking US administrators to teach, protect, and uplift degraded workers. This flattery worked. He was friendly with federal colonial administrators pretty quick. For both Iglesias and Collazo, full disillusionment only came after 1912, when Woodrow Wilson became just the second Democrat since the Civil War to be elected president. Gompers and the AFL had backed Wilson strongly, so Iglesias hoped that the Wilson administration would favor organized labor, including in Puerto Rico. Collazo and other Puerto Rican proponents of home rule had high hopes that Democrats would equate imperialism with Reconstruction, and so provide Puerto Rico the so-called redemption into home rule that the former Confederacy had already secured. But neither was to be. Reconstruction was already vanquished. The Supreme Court had green-lighted Jim Crow and disfranchisement. White supremacists had instituted both throughout the former Confederacy, and they now had a seemingly impregnable hold, politically at least, throughout the South. Their anti-imperialism was always in tension with their racism, and they had little left to fear from the federal government. So they united with Republicans in favor of colonial rule over islanders of color. This was bad news for Iglesias. The population of Puerto Rico was racially mixed. Colonial officials partly measured success by mainland investment. They disliked industrial unrest. President Wilson favored colonial rule of the island. But workers were impatient. Once World War I began, sugar prices spiked. Workers thought their wages should rise too. They struck by the tens of thousands. Now, federal officials, local politicians, and employers opposed the stoppages, some of them violently, and the Wilson administration was unwilling to press employers to protect strikers. Iglesias's vision of dependent citizenship here failed, and the strike collapsed. And this meant that Iglesias now had to scour the government for a new ally. He ended up choosing the congressionally created Commission on Industrial Relations. He presented it telegrams, affidavits, and other records of the ostensible violation of rights and the violence against striking workers. The commission then issued an influential report. In it, it condemned the treatment of striking Puerto Ricans. This was a modest vindication for Iglesias, and he began advocating for citizenship not as a dependent status, but as one that could be used for claiming rights. Of course, the Wilson administration was in no hurry to grant Puerto Ricans a rights-rich citizenship. But withholding citizenship from Puerto Ricans was also unpalatable. Many lawmakers saw it as un-American to rule people as, quote, subjects and not citizens. Puerto Ricans strongly favored citizenship. Its extension would, quote, greatly improve U.S. relations with Latin America. And with U.S. entry into World War I looming, Puerto Ricans' non-citizenship was becoming a source of serious embarrassment. Future Supreme Court Justice Felix Frankfurter provided the solution. Then a young War Department lawyer, he told Congress that it had full control over constitutional rights, citizenship, and sovereignty. Quote, if Congress chooses to grant citizenship but withhold statehood or full constitutional rights in dependent locales, quote, the Supreme Court will respect such exercise. In Collazo's words, citizenship was a, quote, gold brick, worth much less than it appeared. Congress was convinced. In 1916, Congress moved to extend Puerto Ricans' U.S. citizenship. The same bill would deny them full constitutional rights, extensive self-government, promise of statehood, and it would disfranchise them en masse. This last outraged Iglesias, quote, American citizenship disfranchisement, and with Gomper's help, he engineered a counter-campaign that won over key senators. To pass the citizenship bill, Congress dropped the disfranchisement provision, and the Jones Act became law. In the century since, the collective naturalization of Puerto Ricans has made it clear that citizenship was and is important. Iglesias cited Puerto Rican citizenship to gain access to new wartime federal agencies favorable to workers. Collazo found that citizenship made Puerto Ricans into voters. By the time of his 1929 death, he had organized those in New York into a powerful political constituency. Citizenship also distinguished Puerto Ricans from Filipinos by bringing them the enduring freedom to migrate within the United States. Today, more U.S. citizens of Puerto Rican descent live off the island than on it. Back on the island, however, Puerto Rico is still an unincorporated territory. Self-government and constitutional rights there are tenuous. The insular cases are still binding precedent. Harms to Puerto Ricans from racism, associations with foreignness, and lack of federal voting rights are glaring. So is the rare and shocking spectacle of case law as racist as that recounted here remaining largely untouched by time. The impossibility of harmonizing constitutional ideals and imperial realities is a lesson in the perils of empire learned across 120 years and more of suffering for Puerto Ricans. And it is not over yet. I will end there with a thank you and to say I am very much looking forward to your questions.
Thank you very much, Professor Erman. This was a fascinating recitation of history of Puerto Rico, and we will be taking questions from the audience now. If you have questions, please type them into the Q&A section, and we'll get to as many as possible. I'll lead off with the question of what drew you to this topic. I mean, you have a fascinating background and experience yourself with the Supreme Court. What led you to this topic?
Yeah, it's funny. This is a topic that it's one of those stories of how, you know, if following things that are interesting and the connections that come up in life can bring you in unexpected directions. So when I went to graduate school, I had an advisor who studied race and citizenship in Cuba, and I was at an American law school, so I thought I should study something with American law, and Puerto Rico is about as close to Cuba as you can get while staying within US sovereignty. And so I started by just looking at this lawsuit that Isabel Gonzalez brought. And essentially, for a bunch of years, I failed to find out much about her, but learned all these other interesting things about all the people around her. And so the project had this funny donut shape for many years, where I was fascinated by this question that seemed kind of unanswerable, and was producing lots of interesting stuff around it. And it was only fairly late in the project that I started getting real traction on Isabel Gonzalez herself, which then allowed the whole project to come together. And in some ways, it was that interest and that failure together that kind of kept driving me forward to make this the thing I was going to focus on.
Mhm. What are your predictions for statehood? Just to jump ahead.
Yeah, that's a fantastic question. So it's interesting because this was a year where there was a brief moment where I thought maybe the filibuster is going to go away. And the Democrats have control of both houses of Congress and the White House. And those kinds of windows of control are pretty rare and fleeting these days. And we have a highly partisan politics, so it's hard to get much done when you don't have one of those windows of control. And I thought maybe statehood's going to happen this year. Like maybe they'll get rid of the filibuster and they'll think that Puerto Rico being a state would be a permanent partisan advantage for the Democrats, and they will just push it through. It's now looking more and more like the filibuster is going to remain in place, so that it's going to be getting some legislation through is going to be hard if you're not able to get some amount of bipartisanship. It was interesting though, because what you saw among the Democrats was a division. There was one set that wanted to have a constitutional convention in Puerto Rico to let Puerto Ricans articulate what statuses might be of interest to them, and to do that in conversation with Congress so that you could then have a vote in Puerto Rico on all potential available statuses. And there was another group that thought, look, it seems like there's a fair amount of support for statehood in Puerto Rico. Let's just have them vote on that right away. And if that's what they want, we can be done, right, and get it locked in. And interestingly, even now, it doesn't seem like it's been settled which of these approaches is the one that's favored. And the historian in me can't help but notice that this looks a lot like what's happened for 120 years, which is that it gets caught up in the question of what's the best process for settling it? How do we make sure we're doing it right? And nothing happens, right? And then you just end up in a holding pattern. And I think there's some danger that that's what will continue to happen going forward. On the other hand, it increasingly seems like the demographics in Puerto Rico are shifting towards being pro-statehood. So for a long time, statehood independence and some kind of Commonwealth autonomous status split the vote in various ways. And I think if you get a large majority for statehood that's persistent over time, that makes it hard for the United States to continually withhold it. So I guess I see some evidence that that may be emerging in Puerto Rico. And if it does, I'd be hopeful that that would mean statehood would eventually be on offer.
And in the meantime, Puerto Rico is part of the First Circuit. Have you followed the PROMESA, the bankruptcy proceedings going on now in Puerto Rico, and what, it will establish enormous precedent, I think, for bankruptcy proceedings throughout the United States, involving and perhaps defining whether states can seek bankruptcy protections.
Yeah, so it's interesting. I have obviously been following the PROMESA stuff. And for me, the thing that has been most interesting about it is it has this effect on constitutional theory on the island that has immediate political consequences. So one view of what happened when Puerto Rico became a commonwealth was that it entered into a binding compact with the United States that guaranteed Puerto Rico self-government, and that the United States Congress could not alter unilaterally, that the only ways to change this setup was for Puerto Rico and Congress to agree. And the creation of the board to deal with essentially the bankruptcy in Puerto Rico included giving the board quite a lot of powers over governance. And that was done without the consent of Puerto Rico. And so it demonstrated that the compact theory didn't work the way at least many people had thought or hoped it did. And I think that's part of the reason that statehood seems somewhat more appealing to some people in Puerto Rico, is that there's a sense of statehood is a constitutionally protected, constitutionally articulated status that comes with a degree of sovereignty and self-government. And so it can be trusted in a way that Commonwealth status can't be. And of course, the other group that wins on this is people who are interested in independence, be it as a fully independent country or as some sort of very, very close treaty relationship, but technically independent, because that also is a relationship that the Constitution recognizes and speaks about. Traditional Commonwealth status, I think, became harder to defend after the board was put in place and the Supreme Court approved of it.
Well, this has been a great discussion. What are you working on now? What's next? What's up for you next?
So I'm currently at work on a project on jus soli and jus sanguinis, citizenship and their predecessors in the Atlantic world. So we're used to the idea that most countries in the world either have a jus sanguinis regime, which means that their citizens or nationals are determined by descent. If you're a national of a place, then your kids get to be. Or countries have a jus sanguinis regime, which is a birthplace regime. If you're born in a country, then you get to be a citizen or a national of that country. And the jus soli and jus sanguinis are Latin terms. They're understood to be ancient, so people think that they have these long pedigrees reaching back centuries, maybe as far as Roman times. And so I'm working on a project with a co-author right now about how these terms were really first sort of brought into use in the mid-19th century, and that part of their invention was the invention of their history. And so there was an attempt to read them back in time. And that this occurred, part of what this did is it made it so that when people thought about what did it mean to belong to a country, their horizons were narrowed to these two categories. They thought, oh, descent and birthplace are the only ways to think about it and have always been the only ways to think about it. And that involved a process of forgetting a much richer tradition of how to think about it, that other traits might matter and other principles might be at play. And so the project is trying to explore what the world looked like in the before period, and then think about what did it mean that these arose when they did, and how did they shape possibilities going forward.
That'll be interesting. We'll all look forward to that. And you have such insight into these issues. It's going to be great to see where you end up after your work on that. Thank you so much, Sam, for your terrific talk today on Puerto Rico and the Constitution on this Constitution Day, 234th Constitution Day. I do want to remind our audience, as our President Chilton of the Society, President Chilton Varner, said at the outset, that signed copies of Professor Erman's book, Almost Citizens, Puerto Rico, the U.S. Constitution and Empire. I'm going to hold it up here for you to see it. He has signed copies of it, and they're still available from the Society's gift shop. And you can find that at www.supremecourtgifts.org. It's a great read, as this lesson today would indicate, and lecture was a fascinating history. Because this is a new format for us and a new experience for our society and our members, a survey is going to be sent out later this evening to everyone who registered in advance. We hope you'll respond to it. We want to make these programs as rich and accessible as possible. For more information about the Supreme Court Historical Society and our future events, please visit our website at www.supremecourthistory.org. You can register there for our next virtual event, and that's going to be Professors Farah Peterson and Mark Killenbeck, who will be discussing the 1821 Supreme Court term on Monday, October 4th at 2:30 Eastern Time. That's first Monday in October, for those of you paying attention, and those of you, many of you out there who know that that is the day when the Supreme Court traditionally opens its new term. Thank you very much. Thanks again, Sam, and thanks to all for joining us today. We are adjourned.